Good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. So let me formally introduce myself. I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their green card and status in the United States. And I'm also here around 9 o'clock p.m. Eastern Time to take your questions. And so that is what I am here to do tonight. So go ahead and put your questions in the comments right now so that I may answer your questions. And so tonight I want to talk about something that's called the extreme hardship waiver or the unlawful presence waiver. This is a waiver that is available to certain people who don't qualify to stay in the U.S. and apply for permanent residence. And so this is an alternative. So how many chance for VAWA case? So user I-8HR, it really depends on the facts in your case. That's where the consultation is going to be very important. The consultation is where I would be able to evaluate your case to determine whether you qualify for VAWA and how strong your case is. So you can always go to the link in my bio. It will take you to the website where you can call, you can fill out a contact form, or at some times when the scheduling coordinators are available, you could even do online chat between 9:30 a.m. and 11 p.m. on Monday to Friday, and then noon to 5 p.m. on the weekend, Saturday and Sunday. But your chances your chance to succeed in a VAWA case is going to depend on what the facts are. Now, for those of you who are here, you don't know what VAWA is. VAWA is a way to apply for status on your own in the United States if you are facing mistreatment or extreme cruelty by a U.S. citizen or legal permanent resident spouse, a parent if you're under 21, in some cases under 25, or if you are even facing mistreatment or extreme cruelty by a U.S. citizen, son or daughter who's 21 and up. So this could be a way that you could apply on your own in a confidential process without the involvement of the person, the relative who is mistreating you. I have been here for 10 years and have 4 children under 10 years of age, all citizens. What can I do? So Mekins, just having children alone and being here for 10 years is unfortunately not going to qualify you automatically for status here. You would have to be facing certain circumstances, or you would have to qualify through an employer or through a family member. Qualifying family members could be a U.S. citizen or legal permanent resident spouse, a parent, and how long that process is going to be is going to depend on your age, your marital status. And in addition to that, if you're already out of status, then you do face an uphill battle to adjust status in the United States through a parent. The other is to wait for your U.S. citizen sons or daughters to become 21, and they would be able to apply for you. So what I would like to say is, whether you qualify is going to come down to the facts in your case. And so that's where the consultation is going to be very important. So let's see. So Anna B say, hi, what's the first step? So Anna B say, I would need to know what step you're asking about so that I can give you a specific answer. Now, keep in mind the information that I'm giving you tonight is not personal legal advice. It is general information. And so if you would like personal legal advice, the best thing to do is to call and schedule a consultation. My number is all over my videos, and this is, if you go to the link in my bio, you will be able to go to the website, and you'll see all the information you need to get in touch. There are three main ways to get in touch with the office. One is through the online contact form to call the office. There's always a receptionist who is answering the phone, and also even through an offline message system or an online chat. My interview is tomorrow. Any advice? So make sure that you look at the notice, follow all instructions, include all the documents, carry a copy of your application along with the evidence that you attach. And for any further advice, it's going to depend on the type of interview that you have. But if it's marriage-based, it's very important to make sure that you prepare with your spouse so that the both of you are on the same page, that you review your facts together, you jog each other's memory, because sometimes in relationships, in marriages, one person always has good memories. They're kind of like the person that holds all the memories. And so you want to make sure that both of you know your facts and are consistent with each other. You're usually, when you're going into a marriage-based, I don't know if yours is marriage-based, Adlam 22, but when you're going into a marriage-based, sometimes they'll ask you questions based on the history of your relationship. How did you meet? They will ask questions about your wedding. How many people were there? What are your in-laws' names? And then they'll ask about your daily routine. They'll verify that the both of you do in fact live together through questions. So very important you just touch base. And Toy 80, thanks so much for sharing the live. Now, while I'm waiting for more of your questions to come in, I just want to remind you, hi there, Mimi, Florida Realtor. It's nice to see you. Thanks for stopping in. Now, what I want to remind you is that I am also on Instagram. Most of my content is now on Instagram, where you will be able to not only join me live at 9:30 p.m. Eastern time, but you will also get tips and more information through the videos that I post on Instagram. So if you are really interested in getting information that may help you, you can always go to Instagram and follow me. It's on my profile page. The link is there. It's also in Linktree, where there's a button that goes straight to my Instagram page, and there's also an Instagram button on the home page. That's where you can follow me and join lives at 9:30. And that leads me to tell you, I am also going to be going to a pre-scheduled live at 9:30 p.m. Eastern time on Instagram, where we can continue to have this conversation. You can continue to ask your questions when we run out of time here. But I'm still here. I'm still here to answer your questions. So go ahead, feel comfy, put those questions in the comments. I want to see your questions in the comments right now. Now, I came with a topic to talk about, and I think it's important for you to know about, because this information I'm going to give you comes out a lot, especially in personal consultations. Now, I always encourage you to schedule a consultation, but this can guide you and really let you understand or start to understand what you may need to do in your case. Now, if you are here in the United States and you don't qualify for adjustment of status, adjustment of status is the process of applying for permanent residence in the United States, and not everyone qualifies for adjustment of status. Not everyone who qualifies for permanent residence is going to qualify for adjustment of status. That's very important to know, because a very problematic misconception is that some people feel like, well, my U.S. citizen parent is here, I can qualify for the green card. That means I can stay here and apply. Unfortunately, that's not how it works, and it really depends on whether you fall within a category that is allowed to adjust status. And so if you don't fall within this category, so if you're not maintaining your legal status, or you're not the immediate relative of a U.S. citizen. Immediate relative of a U.S. citizen is a spouse of a U.S. citizen, the parent of a U.S. citizen who is 21 and up, or a son or daughter a U.S. citizen, a son or daughter who's under 21 and unmarried. If you're not any one of those, you are not the immediate relative of a U.S. citizen. You fall within another category. And so you wouldn't be able to qualify for adjustment of status as an immediate relative of a U.S. citizen if you're already out of status. You'd have to look at other alternatives, like if VAWA, for example, if you're the spouse of a U.S. citizen or resident spouse or parent, if you're under 21, under 25 in certain circumstances, or you have a U.S. citizen son or daughter who's 21 and up, you're being mistreated or subjected to the extreme cruelty by these relatives, VAWA could offer you a way to apply for status, your work permit, then apply for your permanent residence all on your own. So that's another exception. Also, if you're a T or U visa holder, if you are the victim of trafficking, the victim of a qualifying crime, you've already received your U or T visa, and you've had it for 3 years, you could possibly qualify to adjust status without leaving. Also, if you've received asylum, after a year of having asylum, you could adjust status in the United States. If you don't fall within any of these categories, then it is very unlikely that you would be able to adjust status. You would have to complete the process through consular processing. So I'm going to stop for a minute to answer some questions. Hi, good evening. Why is it only emergency visas they're giving out right now? I'm in the Caribbean. So the embassies are overwhelmed. And then remember that there's a COVID situation. And this could very well be related to them just trying to control the influx of individuals who are coming into the United States during the pandemic. So that is what is going on right now. So keep those questions coming. I am talking about this very important topic. You may not know it's important, but it is important. If you're here, you are out of status and you don't qualify for adjustment of status. So you don't qualify to apply for permanent residence while you're in the United States. Then the next thing is that you have to determine whether you can qualify for a waiver to forgive your overstay and then complete the process at a U.S. embassy in your country or country of your choosing. The reason is, if you don't qualify to stay in the United States, then that just means you have to leave. But this gets tricky, because if you've overstayed over 180 days and you set foot outside of the United States, you will be barred for 3 years at least. If you overstay over 1 year, that turns into a 10-year bar. So really and truly, in order to leave to complete your green card process, to get the green card despite the overstay, you will need to make sure you qualify for this waiver, or else risk being stuck outside of the United States for years while your waiver is pending. So the rule of thumb here is, if you are out of status, you don't qualify to stay in the US and apply, then you need to evaluate whether you qualify for this waiver. Does a 28-year green card holder need his wife's docs to get his citizenship? So he does not need his wife. It's not marriage based, right? Because he has had his green card for 28 years. However, if he's currently married, he will need to provide evidence of his current marriage, but he will be applying based on his own merit and not based on the marriage. Now, I am Nika Marie. If this person is concerned about their any kind of issues, the best thing they need to do is schedule a consultation and get personal legal advice. Because remember, I don't know the particular circumstances, and sometimes my personal legal advice is much different than what I would advise if the facts are even different, even slightly different. It could make a change in the advice that I'm going to provide. So I am now, let's talk about that waiver quickly, and then I'm going to head over to Instagram. So it doesn't have to be the end of our conversation. You can hop on over to Instagram, where you will be able to continue to ask your questions. But if you're in this tough situation where you don't apply to stay and you don't qualify to stay and apply here in the US, you must do your final interview at an embassy abroad. But you know that if you set foot outside of the country, that you'll be barred for a certain number of years, 3 years minimum. Then you need to determine whether you qualify for this. It's called the Provisional Unlawful Presence Waiver. And what it does is it provides forgiveness for your overstay and allows you to wait in the US until your green card interview is scheduled at the embassy, and then you're able to fly to the embassy, and the officer, knowing that you have this approved waiver, will not use the overstay or unlawful presence against you. However, not everyone who's in this situation is going to qualify for this waiver, and that's where you need to make sure that you get personal legal advice. It's based on if you have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardship if you don't get the green card. This process, first your relative or your employer will file the petition for you, and then once it's approved, that's where I help my clients to prepare the waiver and send it in for a decision. Then it's a waiting game from there, but once we get the decision, it allows you to then travel to your interview once it is scheduled, and all being well, there are no other disqualifying facts or issues in your background. You should be good to go. So it is one way to fix your status. It's not usually a way that allows you to stay in the US and apply, but some people don't have the option of staying and applying, and they must go this road. And so this alternative could help you fix your status. Now I'm going to head over to Instagram right now. You can hop on with me over there to continue to ask your questions. So does a 28, so he thought he needs her passport or a citizenship certificate. So I am Nika Marie, have him schedule a consultation because I'm not providing personal legal advice. If he has had his permanent resident card for more than 10 years, for more than, even more than 3 years, usually somebody who has had their green card for that long, they're not applying based on the marriage. So they don't usually need to provide evidence of their spouse's citizenship. But who knows? I don't know what the circumstances is in his case, and that's where it's important for him to get personal legal advice to make sure that he is approaching this correctly. One thing I will say is now is a good time to apply for U.S. citizenship. So if you are thinking about it, call me, schedule a consultation. Let's confirm you qualify, and I apply for my client's citizenship application very quickly after we get started. So have a good night. If I don't see you in a minute on Instagram, see you tomorrow. Look out for me tomorrow at 9 p.m. Eastern time, where I will continue to answer your questions. So my lawyer sent my husband to Mexico for his appointment. Now he can't come. What's next, please? So that is a complex issue. And so usually, unfortunately, what happens is sometimes you apply for this unlawful presence waiver, and if there are other issues in the background of this person, so for example, if there's misrepresentation or an arrest issue or some other type of inadmissibility, then that is where problems can start, because this waiver is only for individuals who only have unlawful presence as their immigration violation. So join me on Instagram right now. Just hop on over to Instagram and join me, and you can continue to ask your questions there. So sorry that has happened to you, Idalia. And if you want a second opinion, you can always schedule a consultation. But if your if your husband is represented by attorneys, you need to consult with your attorneys because they can tell you the best approach. But if you feel like you're in a situation where you're not being helped and you need a second opinion, I'm always available to provide that. So I'm going to head over to Instagram right now. If I don't see you on Instagram, I hope to see you tomorrow or speak with you in a consultation. Have a good night.